29 of the Prevention of Terrorism Act 2012. And the particulars of the offense are that on or before the 23rd of January 2019, at Umoja Estate within Nairobi County, in preparation or facilitating the commission of a terrorist act, he collected and transmitted information on security arrangements of Kenyatta International Conference Center using his mobile phone, make Infinix 04 Plus, on a Facebook account, Mohammed Yare Abdallah, which information was to be used in commission of a terrorist act. In support of the charges, the prosecution called a total of 11 witnesses. I have recorded the evidence of the 11 witnesses and analyzed the same in my judgment, but I will not read out that analysis for the witnesses. After the court found that the accused had a case to answer at the close of the prosecution case, and the accused person gave sworn evidence in defense. He denied all the charges against him. I will also not go through his evidence, but I have also analyzed the evidence of the accused person in the defense. After the close of the prosecution case, submissions were filed by both parties. Accounts Mohammed Yare, Abdallah, and Abdul Hakim. And that by virtue of the admissions, Actus Reus had been proved beyond reasonable doubt by the prosecution, and the same should not be ignored. The prosecution relied on the case of Republic versus Peter Kizaka Kiriga. The prosecution also submitted that the elements of the charge of conspiracy charge had been proved as an overt act had taken place, that the accused had been instructed by his cousin Elgiva Bwire to open a Facebook account through which he could receive instructions, and this happened, and the accused put into motion the instructions on surveillance. He received payments for the same. The accused thus collected information on behalf of Mohammed Yare Abdallah for purposes of committing a terrorist act at KICC. The prosecution dismissed the defense by the accused that he had business relationship only with Mohammed Yare, and stated that they had demonstrated that the accused collected information which he passed to Mohammed Yare with a view to commit a terrorist act. They asked the court to find the accused guilty of the offense. On the other hand, the defense submitted that the prosecution had failed to prove its case beyond reasonable doubt. The defense submitted that the prosecution case was based on circumstantial evidence, but the circumstantial evidence as tendered failed to irresistibly point at the accused person as a conspirator or co-conspirator to commit a terrorist act at KICC. The defense submitted that the defense by the accused completely weakened and destroyed an inference of guilt on the part of the accused person on the two counts. The defense relied on the case of Republic versus Kipkereng Arap Koske, Republic versus Taylor Weaver and Donovan, Sawe versus Republic, Neema Mwandoro Nduria versus Republic, and the case of Yusuf Nkuru Gitonga. The defense further submitted that the evidence by the accused that his communication and relationship with Mohammed Yare was purely business centered, with no links or association with terrorism, was not rebutted, and there was no proof that Mohammed Yare was a terrorist. The defense further submitted that the prosecution case was based on suspicion, which could not be the basis of a conviction, and relied in this respect on the case of Mary Wanjiku versus Republic, and further that the ingredients of the offense of conspiracy to commit a terrorist act as set in Nicholas Shivachi Mboya and another versus Republic case had not been proved. They also submitted that the Facebook records, which were heavily relied on, are inadmissible, as no witness was called from Facebook Incorporated to produce them or authenticate the same. In conclusion, they submitted that it was not proved that the accused was possessed of the relevant mens rea and actus reus to commit the offense as charged, and therefore the defense asked the court to discharge the accused under Section 215 CPC. It is our cardinal principle of law that in a criminal case, the legal onus is always on the prosecution to prove the guilt of an accused person, and the standard of proof is proof beyond reasonable doubt. The burden of proof, therefore, always lies on the prosecution throughout to prove the guilt of an accused person. These are the provisions of Section 107 Evidence Act and 108 of the Evidence Act. An accused person, therefore, does not assume any burden to prove his innocence in a criminal case. He is obliged only, if he so wishes, to give an explanation or to raise a defense to the charge, which is probably or possibly true. If he does this, then he discharges his burden of proof, and his explanation or defense must be accepted. I have considered the evidence of the prosecution and the defense witnesses, and the written submissions filed by the prosecution and the defense. The issue for determination is whether the prosecution has proved both the charges against the accused beyond reasonable doubt. The case against the accused is that the accused was introduced by his cousin, a convict at Kamiti prison by the name Buire Elgiva, to certain individuals on Facebook who instructed him to assist them by carrying out surveillance of KICC and give security information. He was allegedly instructed by the same persons to carry out surveillance from Nairobi to Moyale and Wajir, and note the location and number of roadblocks along the way, and also to give a report of the manner the police conducted searches in the vehicles and how the luggage was searched. The prosecution alleges that the intention of the terrorists in seeking this information was to carry out a terrorist act. The prosecution states that the accused was cautioned to be very discreet, and in that regard, he was required to communicate with the terrorists using discreet Facebook accounts. And in this regard, it is alleged that the accused opened 3 Facebook accounts, that is Kezia Soze, Soze Kezia, and Kim Sam, which he used to communicate with Mohamed Yare Abdallah and Abdullah Kim, the masterminds. According to the investigating officer, upon the arrest of the accused person, 3 mobile phones were recovered from him, and upon interrogation, the accused person gave out crucial information relating to his Facebook activities using the mobile phones. This prompted the investigating officer to forward the phones to DCI Forensic Lab for forensic examination and analysis to verify the information by the accused person. PW8 Inspector Kolum from DCI Lab testified that he exploited the phones, and he found that the Samsung Galaxy phone GTI 93011 was linked to Facebook account Soze Kezia by way of browsing. That the Nokia TA1010 was being used by a phone number 0740 462533 in the name of Sadiq Muse. He also established in his exploitation that phone number 0700-76524 registered to Irene Ndinda was used to open the Facebook account Kezia Soze. Inspector Kolum stated that upon exploitation of the Infinix phone, it was linked to phone number 07404-62533 belonging to Sadiq Ali Muse. It received some money from Ahmed Mohammed and that it was being used by Facebook user Kim Sam and Kezia Soze, and that it was receiving instructions from Mohammed Yare. Inspector Kolum stated that he established that the three Facebook user names Kezia Soze, Soze Kezia, and Kim Sam were used by one individual, and that is the accused person. In his defense, the accused person confirmed that he was the one using the three accounts, Kezia Soze, Soze Kezia, and Kim Sam. The accused also confirmed that he was the one communicating with Mohammed Yare through Facebook, and confirmed that Mohammed Yare advised him to stop communicating with him using a phone number and advised him to use Facebook. He confirmed that indeed he gathered some information for Mohammed Yare, but stated that the information that he collected was not meant to facilitate a terrorist act, but was for general awareness of Mohammed Yare, who was an exhibitor and intended to perform all the relevant case information which provides meeting that the defense in the position he came in through a mutual legal assistance between Kenya and the USA, and that a request was made to them to apply for USA search warrants for the Facebook accounts Kezia Soze and Mohammed Yare Abdallah. That they made the application for the warrants before the United States Advocate Judge, who granted the orders, and upon receipt of returns, they disclosed other accounts in the conversations, in particular Abdul Hakim and Kim Sam and Soze Kezia. When the said officer, John Scott, testified in court and produced the Facebook conversations, the accused did not object to production of the same. The same were actually produced as exhibits, and therefore I find that the objection to rely on the Facebook communication has no basis and is dismissed. Besides, the accused himself in his defense admitted to have opened the Facebook accounts and having been the one communicating with the alleged persons. The submissions that the Facebook conversation should be disregarded is therefore dismissed. The particulars of the charge in count 2, I'll start with count 2, where the particulars of the charge are that in preparation or facilitating the commission of a terrorist act, the accused collected and transmitted information on security arrangements of Kenyatta International Conference Center using his mobile phone and Infix 04 Plus. On Facebook account Mohammed Yare Abdallah, which information was to be used in commission of a terrorist act. The conversation about KICC is contained in exhibit number 11 between page 48 and 39. It starts by Mohammed Yare asking Kezia Soze, that is the accused person, whether he had visited KICC, to which the accused replies that he had visited the place many times. It is noted from the conversation between them before this that this is a conversation. This conversation is after the accused had visited Elwak, where he had met Mohamed Yare. In summary, Mohamed Yare seeks to know the level and seriousness of the searches at the entrance to KICC, and the accused tells him that the searches were not very serious, portraying a picture that the security arrangements were lax at KICC. The next issue he wanted to know was the number of gates to KICC, to which the accused tells him that there are 4 entrances. The location of the gates is also given, the distance from the gates to the building. Mohamed Yare also seeks to know whether any of the gates was not being used, to which the accused informs him that one from the Supreme Court was only for entrance and for VIPs. Mohamed Yare also seeks information on the number of doors to KICC and the location, which the accused person gives in his response, explaining the doors leading to one of the rooms, that is the Savo ballroom, which he explains is on ground floor. He also explains the toilets, the loading zone, and other areas. The accused is also asked whether there is a parking within the building, to which he responds that there are 3 parking areas. That is Arambe Avenue side for staff, Parliament entrance side, and the City Hall entrance side, which he describes. The question that one then asks is whether the above information was being collected in committing or instigating, preparing, or facilitating the commission of a terrorist act. There is no direct evidence that the information was meant to assist in the commission of a terrorist act, but the prosecution largely depends on circumstantial evidence to pin down the accused person to the offense. In the case of Ahmad Abul Fathi Mohammed and another versus the Republic, the Court of Appeal said as follows regarding circumstantial evidence. And I quote, however, it is a truism that the guilt of an accused person can be proved by either direct or circumstantial evidence. Circumstantial evidence is evidence which enables a court to deduce a particular fact from circumstances or facts that have been proved. Such evidence can form a strong basis for proving the guilt of an accused person, just as direct evidence. Way back in 1928, Lord Hayward C.J. stated as follows on circumstantial evidence in the case of R versus Taylor, Weaver and Donovan. And I quote, it has been said that the evidence against the appellant is circumstantial, so it is. But circumstantial evidence is very often the best evidence. It is evidence of surrounding circumstances which, by intensified examination, is capable of proving a proposition with the accuracy of mathematics. It is no derogation from evidence to say that it is circumstantial, end quote. In the case of Abanga Elias Onyango versus the Republic, the Court of Appeal held as follows regarding circumstantial evidence. And I quote, it is settled law that when a case rests entirely on circumstantial evidence, such evidence must satisfy 3 tests. 1, the circumstances from which an inference of guilt is sought to be drawn must be cogently and firmly established. 2, those circumstances should be of a definite tendency and erringly pointing towards the guilt of an accused person. And 3, the circumstances taken cumulatively should form a chain complete, that there is no escape from the conclusion that with all human probability the crime was committed by the accused and none else. And in Sawe versus Republic, the Court of Appeal reiterated the above and stated as follows: that in order to justify on circumstantial evidence the inference of guilt, the inculpatory facts must be incompatible with the innocence of the accused person and incapable of explanation upon any other reasonable hypothesis than the guilt of an accused person. There must be no other coexisting circumstances weakening the chain of circumstances relied on, and the burden of proving facts that justify the drawing of this inference from the facts to the exclusion of any other reasonable hypothesis of innocence remain with the prosecution. It is a burden which never shifts to the party accused. In this case, 4 key strands of evidence tend to connect the accused person with the offense, and the same follow each other chronologically in terms of happenings, and all are deducted from the Facebook conversations. So the first one is the nature of engagement. At the beginning of the conversations and at the point where the accused is introducing himself in the conversation between Kim Sam and Abdul Hakim, the accused is asked whether he is ready for Hijrah. He confirms that he is ready. He is asked whether he is ready for the job at hand. He is warned that it is not an easy job and warned never to trust anyone, not even his own friends, his wife, or even sheikhs. He is also warned that there was a lot of espionage and surveillance, and therefore the need for secrecy. He is then asked to read certain books to prepare him, and given timelines to finish reading these books. The books were purchased for him by the sponsor. He asked to confirm purchase of the same, and was asked to send the photographs of the books once he had purchased them. This kind of engagement, in my view, is consistent with a plan to engage in a terrorist activity. The second strand is concealment of identity. The fact that the accused was instructed and attempted to conceal his identity could be an indicator of his intentions. The accused was advised to drop use of his mobile phone number. He was asked to use Facebook accounts. He did not use his own phone number or name to open the Facebook accounts, but used other people's numbers. And for instance, the account Kezia Soze was opened using a line belonging to one Irene Dinda. The line was borrowed by the accused's wife and taken by the accused and used without her knowledge. The accused was also using phone number 0740462533, which was registered in the name of Sadiq Ali Muse, to receive money from the sponsor, and thus avoiding his own numbers. When the third aspect is the nature of surveillance and movements. The accused person was tasked to travel from Nairobi to Marsabit and Wajir twice. First, using his motorbike, for which the sponsor paid his fuel, for driving license and insurance. And the second time, using a bus, which was which trip was also fully paid for. The accused was asked to report on, which he did, the number of police roadblocks on the way, the location of the roadblocks, whether the motorcycle was being stopped by the police, how many times it was stopped if so, and whether they asked for ID cards for the rider and the ID card for the rider and the pillion passenger. He was also asked to carry luggage on the motorbike and a passenger and asked to confirm whether the luggage was being searched and whether the passenger ID was also being asked. The same thing applied to the bus trip. He was asked to confirm the number of roadblocks, the nature of searches in the bus, whether luggage was checked, and generally the alertness of the security officers along the way. From this kind of information requested, it can be deducted that the attackers intended to travel to Nairobi using a motorbike or a bus, and the information requested was to assist in assessing the best mode of transport for the attackers, would naturally choose the least checked. It would also appear that they intended to carry some luggage and so to know whether it was checked. This kind of information is critical for anyone wishing to perform a terrorist act. So the fourth aspect is the place of attack and surveillance. From the conversations, as already stated above, several questions were asked about KICC. The nature of questions related to the entrance, number of entrance gates, the location, the security of the gates, the distance from the gate to the building, doors to the building, and the parking locations, and the alertness of the security officers. This information is necessary if one was to perform a terrorist act at KICC as alleged. From the foregoing, it is difficult for anyone not to conclude. Sorry, from the foregoing, it is not difficult for one to conclude that the information was for purposes of carrying out a terrorist act. But what is the accused's response to all these allegations? As earlier stated, the accused person stated that though he gave the information, the same was not intended to assist in the commission of a terrorist activity. He stated that Mohamed Yare was a client for his business of events organizing, and he wanted the information because he wanted to organize a Somali cultural event towards mid-2019. So the question is whether this defense is believable or reasonable. I, however, do not think so. To start with, there is no doubt that the accused person knew KICC very well, having worked for a company called Altec Africa, as confirmed by PW2, a principal security officer at KICC, and his workmate then by the name Martin Dolo. The accused confirmed that he left the company and joined Martin, who started his own events management company, but he again stated that they parted ways with Martin, and he claims to have opened his own events management company at the same venue. The accused person did not produce anything to show that he was operating an events management company, and the testimony of Ahmed Abdi, PW1, who stated that he knew the accused person as a motorbike operator in town and used to send him to deliver luggage to his clients, confirmed otherwise. In his introductory conversation with Abdul Hakim, the accused person also introduced himself to Abdul Hakim on 2nd of June 2018 as a motorbike rider in town, and therefore the statement made by the accused in defense that he was an event organizer was not factual. He was a motorcycle rider within CBD in Nairobi. As regards the alleged planned cultural event by Mohamed Yare, the accused did not avail any evidence to support or convince the court about the same. One wonders, if Mohamed Yare wanted to do an event, why would he disguise himself? Why would he secretly seek the security details stated above and in a secret manner? As an exhibitor, also as an exhibitor, the most likely questions expected of a venue would be the accessibility of the venue from transport, public transport stations like bus stations, railway station or airport, the ambience and accessibility capacity of the halls or the tents, services and amenities like kitchen and catering, chairs, tables, linen, public address systems, insurance, etc. The said Mohamed Yare appeared not interested in any of this. My take is that there is no connection established between organization of an event and the nature of questions asked by Mohamed Yare Abdallah. The accused also stated in passing that Mohamed Yare was a wholesaler of sugar and that he wanted information so that he would avoid the roadblocks when distributing sugar. Was this the reason the accused was being prepared to travel to Marsabit and Elwak to collect information? Did the accused have to disguise himself as a NTV intern for him to obtain the information on routes for sugar to pass? My answer to the above is no. The accused must have been after something more. The accused person also did not give an explanation on his own why, if he was in business of event organization, he undertook the mission to carry out surveillance of the nature he did. Why he had to hide his identity while communicating with his so-called client, why he agreed to collect lost identity cards for use, and also the relationship of the hijrah he had undertaken against the business. From the above, it is my finding that the collection and transmission of the information about KICC by the accused person cannot be looked at in isolation, but must be looked in conjunction with the information collected by the accused before, which detailed the security situation on the road from Wajir, Marsabit, and Nairobi, and also must be looked at with the conduct of the accused person, the discreet manner in which he was operating while collecting the information, and looked at cumulatively. I find that the information was for no other purpose, but it was geared towards and meant to aid the noteworthy, where the dominant aspect of the offense of conspiracy is agreement. Is whether the prosecution has proved to commit a terrorist act in this case, but from the fact of the accused. The conversation between and Mohamed Yare Abdallah shows that they were the ones, and at the beginning, when introducing themselves to Mohamed Yare, the accused person was asked whether he was ready for the task at hand. He clearly stated that he was ready for the assignment despite the dangers involved in the intelligence. The two had a meeting of minds and agreed on what was to be done. An agreement was made between the accused and the mastermind on the modus operandi, how he would operate by disguising himself by use of Facebook, different Facebook accounts, and how he would behave on Facebook by liking and inviting friends whom he did not even know, so as not to attract attention. By opening accounts using local data, use of posting, and also an agreement on the kind of information that was being collected. The accused constantly received money and that there was clear evidence that the prosecution has also proved summary, the prosecution has proved both counts without, and the accused is convicted on the same. So that is the gist. Yeah, that's
and at the same time, we think that the protocol is to be set is the victim's impact statement, as well as Your Honor to confirm whether the accused person has had previous criminal records. And finally, for the prosecution to make final submissions about the sentencing. Your Honor, for that reason, we are kindly asking if you could come back, Your Honor, on the week of the first. Your Honor, we are looking at. I am not available next week, and after next week, Your Honor, we will be here with Mr. Chester for a back-to-back hearing. 8th of February, for victims impact statement, submission for sentencing, and mitigation.
I've noted just a slight, I think, typos, which I'll correct in a few minutes. Can be available. Thank you. So the court is adjourned.
Sorry.